Good evening, everyone. I'm Mary Pat Higgins. I'm the president and CEO of the Dallas Holocaust and Human Rights Museum, and it's my pleasure to welcome you to tonight's program, the Supreme Court Balance of Power, which is part of our Civil Discourse Series. I'd like to start by saying a special thank you to our presenting sponsor for this series, the Meadows Foundation. Thank you so much for making the Civil Discourse Series possible. We're so grateful. I'd also like to thank our community partners for this program, and bear with me, we have quite a few. Bounding Prosperity, Bethel Benah, Equality Texas, Green Hill School, Hope Supply Company, League of Women Voters of Dallas, SMU Dedman School of Law, SMU Human Rights Program, Southwest Jewish Congress, Temple Shalom, and the Legacy Senior Communities. What an incredible group of community partners. We couldn't put on these types of events without your support. And as always, I'd like to give a warm welcome to our board members who are here. I've seen so many of you, to our volunteers, and to our museum members. We could not do our work without the support from all of you, and I'm so grateful. And if you are not a part of the Inner Club, I invite you to join us. We would love to have your support as members to help us put on this type of programming, and we'd love for you to get engaged as a volunteer. So please, there was a membership booth out front tonight. You can get information about membership and volunteering on our website. So please go to dhhrm.org. So the goal of our Civil Discourse Series is to present multiple sides of a thought-provoking topic through respectful discussion, which we don't hear much these days. We see our role in the community not only as an educator, but as a convener, serving as a place where we can gather to learn from one another. Tonight, we will discuss the United States Supreme Court and the public debate about its role and influence that has been stirred by recent Supreme Court decisions. I saw many of you before you came in to the auditorium this evening visiting our special exhibition gallery. For those of you that haven't visited it yet, I urge you to visit the gallery. It's Black Citizenship in the Age of Jim Crow. And through that exhibit, you can see how central the Supreme Court is to the functioning of our democracy, for good or for ill. The Supreme Court ruled in Plessy v. Ferguson in 1896 that segregation in the form of separate but equal was acceptable. Then, in Brown v. Board 1954, the court ruled that separate but equal was unconstitutional. I highlight these two cases because each speaks volumes to the role of the Supreme Court at different moments in our history. This is an ongoing discussion, and it has waxed and waned over the years, and as we will learn from our panelists tonight. So we're in for an interesting discussion. For those of you that have questions for our panelists, we hope that you'll write your questions on the note card that you received when you entered tonight. Our staff will come around and pick them up. For those of you joining us via Zoom, please put your questions in the chat, and we will answer as many questions as possible. So before we get started, I'd like to briefly introduce our panel for this evening. Joanna L. Grossman is the inaugural Ellen K. Sollander Endowed Chair in Women and the Law at Southern Methodist Dedman School of Law. Southern Methodist University, Dedman School of Law. Grossman writes extensively on sex discrimination and workplace equality and is an expert in family law. Her books include 9 to 5, How Gender, Sex, and Sexuality Continue to Define the American Workplace, and Inside the Castle, Law and the Family in the 20th Century of America. Frederick M. Lawrence is the 10th Secretary and CEO of Phi Beta Kappa Society, the nation's first and most prestigious honor society, and a distinguished lecturer at the Georgetown Law Center. An accomplished scholar, teacher, and attorney, Lawrence is one of the nation's leading experts on civil rights, free expression, bias crimes, and higher education law. He is the author of Punishing Hate, Bias Crimes Under American Law, and frequently contributes op-eds to various news sources. Roman Martinez is the Deputy Managing Partner of the Washington, D.C. office of Latham & Watkins, LLP. A member of the firm's Supreme Court and appellate practice, he focuses primarily on appeals in the Supreme Court and federal and state courts of appeal. He has argued 13 cases before the Supreme Court involving a wide range of legal issues, including the First Amendment, copyright, arbitration, civil rights, and criminal law. And our moderator tonight is Lauren Jacobson, an associate professor of law at University of North Texas at Dallas College of Law, where she teaches courses in healthcare law, constitutional law, and civil rights law, among others. Her scholarly writing has focused on the First Amendment's commercial speech protections, reproductive rights, and the non-delegation doctrine. It is now my pleasure to turn it over to our panelists. Thank you.
Thank you so much, Mary Pat. I'm honored to be here and honored to be able to moderate this panel with these very esteemed guests and experts. So let's get started. I will start with a basic question. Can you tell us what is the structure, purpose, and role of the Supreme Court?
Who's going to bite on that one? Right. Article 3 of the Constitution is actually very spare in its text. Earlier on in my academic career, I taught the basic course in civil procedure, and I usually would start with Article 3 just as a text to try to tease out what it says and where it leaves gaps. But it does say that the judicial power of the United States shall be vested in one Supreme Court. Doesn't say how many justices should be on that Supreme Court, doesn't exactly say what that judicial power is, but what has evolved over the centuries is that the court is the ultimate decider of the law. That's what Chief Justice Marshall told us back in the early 19th century. It is the interpreter of the Constitution, and it is the final source of judicial review with respect to federal matters. I emphasize federal matters because there's an entire state system that, unless it conflicts with the federal Constitution, has nothing to do with the United States Supreme Court. But anything that affects federal law, and particularly the Constitution, it is the province of the Supreme Court to be the one that ultimately decides actual cases and controversies as opposed to what? As opposed to giving advice. That's something that President Washington found out right at the beginning when he rather sensibly asked the Supreme Court for their view on something. And the court said, we're not in the business of doing that. We don't give advisory opinions. It is tempting to think of things as they are, as the way they must be. So sometimes examples of how it might otherwise be is useful. Commonwealth of Massachusetts, where I spent a good deal of time, the Supreme Judicial Court actually can give advisory opinions. One of the most famous ones that some of you will remember was when Michael Dukakis, who unsuccessfully ran for president along with your Senator Lloyd Bentsen as his running mate in 1988, Governor Dukakis asked for an opinion about whether students could be required to salute the flag. The Supreme Judicial Court said they could not, so he went along with that. And he had that hung around his neck in that 1988 election that he was against the flag salute. So moral of the story is that courts can give advisory opinions, but if you're a governor, be careful what you ask for.
Anyone want to add anything about the structure or role of the Supreme Court?
I'll just add a little bit. I mean, picking up on what you said about people assume things have to be the way they are now or were. So, for example, the number of justices on the Supreme Court, which is certainly a modern topic, that's not fixed. Congress dictates how the federal courts are organized and how many Supreme Court justices there are. So there have been as few as 5, as many as 10. And the number we have now is 9, and that's been since just after the Civil War. But that is one of those things that people treat as if it is what it is, and we couldn't ever do it. That would be the end of democracy if we were to pack the court or change the number of justices, and that's a good example of something that actually does change from time to time depending on, various political issues. And there are other things built into the structure of the Supreme Court that are supposed to insulate it from politics. Asterisk. Doesn't do it very well. But there are features like, for example, that federal judges serve with life tenure, and they can't have their salary reduced by the legislative branch once they are in office. And so there are some other things in there that are designed to make the court different and special from other governmental bodies, and we'll, I'm sure as the night goes on, talk about how well it does or doesn't do that. But it is a sort of complicated set of institutions, and the lower federal courts, so there's the Supreme Court, which we talk about all the time, but actually most of the work being done, applying various legal principles, interpreting things, et cetera, is mostly in the lower federal courts. So the entire body of district courts, which are the trial courts in the federal system, and the appellate courts, they have vastly bigger dockets and reach than the U.S. Supreme Court. But of course, what the U.S. Supreme Court says matters more.
I'll just add one thing, which is sort of how the founders were thinking about the Article 3 judiciary with, of course, the Supreme Court at the top. The Federalist Papers, Federalist number 78 is probably the most important Federalist paper when talking about the role of the judiciary. And it was written by Publius, but really by Alexander Hamilton, who we all know from the musical. And I'm not going to rap Federalist 78. But the founders and the Federalist Papers sort of articulated this view, saw the judiciary as the least dangerous branch compared to the other two branches. Because in their view, it had the fewest sort of powers and the least independent ability to kind of do things just on its own. So, Federalist 78 talks about the fact that the executive has the power of the sword, the power to execute the laws. The legislative branch has the power of the purse to control how money is spent. And the Article 3 judiciary doesn't have any of those things. And that's why it needs to have special protections and independence from the other branches. And I think in a phrase that I think is very meaningful, Hamilton says in Federalist 78 that the courts exercise neither force nor will, but merely judgment. So force is the executive branch, will is the legislative branch. Courts are supposed to be doing something else, which is to exercise judgment. And as Fred was saying, really that means the power to say what the law is, quoting from Marbury versus Madison.
Great. So Joanna mentioned that Supreme Court justices are not term limited. They serve for life. And she also mentioned that one of the points of this is to insulate them from politics. Can you discuss, so that's, I guess, one of the pros of a lifetime appointment. Can you discuss the pros and cons of a lifetime appointment and whether you think that the provision for lifetime appointment should be changed? And what would need to happen for that to change?
I'll jump into that. I'm in favor of lifetime appointments. Mm-hmm. I think the founders got this one right. I think certainly it would be a terrible thing to have sort of short appointments that could be renewed, because then you would have the problem. I don't know if any of you have ever heard of Congress, and we see congressmen out there, and what do? As soon as they get elected, they start thinking about the next election. And when you're thinking about an election, you got to figure out who's going to be picking the next congressperson. And I think it would be not a great idea to have judges out there either every 2 years, 4 years, 8 years, whatever, thinking about what they would need to do to get political actors, politicians, to reappoint them. I think you could achieve probably a lot of the similar objectives of a lifetime appointment if you just had a really long appointment. So if you had like a 20-year term or a 15 or 17-year term, maybe that wouldn't be the end of the world to change that. You would need to, I think, change the Constitution to kind of have that sort of change. But in general, the idea of having folks who are there for a long time, who are able to, become even wiser in the law over an extended period of time, and have them insulated from constantly having to kind of face the voters or face the politicians and justify themselves in that way, I think is very important to maintaining an independent judiciary.
I agree with most of that except the conclusion. I do think, and I'm not being facetious actually, and it may have something to do with civil discourse as a goal for tonight. So I think the idea of insulating judges and justices from perpetual elections is certainly wise, just for the reasons you suggested. You don't want somebody as a judge thinking, how is this going to look when I come up for re-election? And even in states that seem to function reasonably well with elected Supreme Court justices, there is something unseemly about some of those elections, and there's something particularly unseemly about somebody raising money in order to run for the Supreme Court of a state. So there's something to be said with insulating them. But that could be done, as you say, with a long sentence, a long term. It feels like a sentence sometimes. A long term, 14 years, what New York State has, but making it non-renewable would also solve the other problem. What I wanted to address was whether the Constitution has to be changed. My understanding of Article 3 is that once appointed, a judge cannot be terminated from being a judge, except for cause, high crimes and misdemeanors, and cannot have their pay reduced while in office. But I don't see that Congress couldn't say that once you're appointed to the Supreme Court, you serve for 14 years or 15 years or 20 years as a Supreme Court justice, and then you have life tenure as a federal judge. But you become a Court of Appeals judge by designation, much as David Souter does right now in the First Circuit in New Hampshire, and other Supreme Court justices who have retired remain active as Courts of Appeals judges. I wouldn't say it's the rule, but there's certainly been those who have. And so you would continue in your role as a judge under the life tenure, but not as a Supreme Court justice. So I think it would be a very hot political issue, to be sure, but I think Congress could do it with their power.
Would you vote for that law? That sounds like a very bad idea.
Well, I'll tell you the reason I would vote for it is that I think we have created a situation where presidents, both parties, have decided to try to appoint the most capable young person they can appoint with the hope of influencing the court for years and years and years, and that may just be longer than any one person should have the ability to do that. So the idea that has been floated of 18-year terms and every 2 years one comes up so that every president has some appointments, no one like President Carter gets 0, and no one winds up with an extraordinary number, and limits the influence that any individual president can have. I think there's a lot of merit to that.
Yeah, so I can't remember where you started, but I think I disagreed with everything, including the conclusion, which is probably not that surprising.
So
but,
that's how it's going to be tonight.
Although this is not like
There's a reason you're in the middle.
Not one of my important issues.
Did not expect life tenure to be the hot button. I'm sure there are a lot of other ones too.
Well, there are a couple things. So first of all, the fact that we're appointing people that are so young, right, some of whom are not yet qualified, right, is a problem. And I teach family law, and when we talk about divorce, and everyone says, oh, it was so great when marriage was for life, and we had, nobody could get divorced, you have to remember the life expectancies were 40, right? And so the truth is most marriages today last about the same length, but they end in divorce instead of with death. And it's a little bit of the same problem with the Supreme Court, and one of the problems we're going to be talking later about originalism is when we have rules that were set down 250 years ago, there were actually different conditions in place, one of which is that people were not living to be 85, 90, 95 years old and potentially being on the Supreme Court for 40 years, 45 years. And I think that's a new thing we have to think about. There is no reason why one president should get no Supreme Court appointments and the next one should get 3, or not in that order. That's not exactly how the chronology went, but and because in fact the president is what most reflects what people in the country are supporting or voting for, and so you end up with right now a Supreme Court that is very far to the right of where the country is, no matter how you count votes, preferences, or whatever. You cannot make a case that that Supreme Court in any way reflects what the majority of Americans would envision for the Supreme Court. So I think thinking about 18, I'd give them 18. You don't want to do just what New York did, but I would do 18-year terms to stagger it so that it was. And you'd have to come up with some complicated rules if somebody dies or quits, and there would be some things to work out, but that's why we have lawyers and all those DC people. You give you a whole nother job. You could be sitting there and figure out how to exactly structure that. But I think it's certainly something worth looking at seriously, and that goes in the camp of we shouldn't just do things the way we've always done them because we've always done them, because that is not really a good path. And when you mentioned some states seem to survive with all elected judges, we're those states. Whether we're
How's that work-
surviving
how's
is a
that
different
working?
question.
Working out.
However, we do, in fact, our entire judiciary in Texas is elected, and there are some good aspects of that and some problematic ones.
All right, so to stay a little bit on lifetime appointments, as we talked about, the whole point is to protect justices from the influence of politics. So let's go there. The Supreme Court is meant to function as an independent judiciary that theoretically is not subject to partisan pressure. Do you think this holds true? Or do you think partisan politics have an impact on the Supreme Court justices and how they rule in cases?
First, and then you can counterpoint me. So that is such a complicated question, right? Such a complicated issue. And I don't think the answer is the same right in this moment that maybe the answer would have been even a year or two ago or 5 years ago or 8 years ago. So that's how complicated I think it is. So I think in general, there's something to be said for lifetime appointments providing some insulation. I mean, we can give you lots of examples of state judges who were elected where they, for example, the Iowa Supreme Court, which was one of the very first states to legalize same-sex marriage, and that came through a judicial decision from the Iowa Supreme Court, 4-3, and all four of the judges in the majority were called in the next election. Not just not elected again, but actually pulled off the court. And there are lots of other examples of that where very reactionary moments, and that makes judges as political as possible, right? When every opinion they issue, they know is being scrutinized, and that's going to be a campaign flyer, and it ties politics and the courts in a way that really is kind of unseemly. So I do think the lifetime appointments help with that. On the other hand, if you look at all the things coming out this year about Clarence Thomas and Justice Alito and the pressures / possible ethical issues, from their relationships with donors and political activists and the role of the Federalist Society in shaping, a very conservative judiciary, I think we've kind of assumed there's a level of insulation that is probably not at the level we think it is. And so, again, worth taking another look at whether our premises are true and whether they're leading us to the right answer. But I think if you look at the current Supreme Court, it's just a very good reminder that law is basically politics, and courts, whatever features you put in there, are basically political branches. And I certainly would not in any way today, although I love Alexander Hamilton, love it, saw the original cast, been there. But the idea that the Supreme Court is part of the least dangerous branch is today doesn't make any sense, right? Because in fact, they do all kinds of things that are very dangerous.
So there's a lot to disagree with there. I think what I'll say, just to go back to the question, I do think I have a much less negative view of the court in general. I think the court actually does its very best to operate in a realm that's outside of politics. I think it is important to say that while the justices and judges generally are supposed to be insulated from politics once they're on the bench, the founders also were, they placed the appointment power in the president, and they required the Senate to consent to the appointment. And they knew that that would be a political process. So even the Constitution itself doesn't try to fully remove at least the appointment of the justices. I think once they're on the court, in my experience, I think there are a wide range of views among the justices in terms of their judicial philosophy, which produces a wide range of judicial outcomes. I clerked at the court. I've argued a lot of cases at the court. I do not think, I would strongly disagree with the notion that the court is motivated by partisan outcomes. Like they see themselves as sort of serving the interests of the Republican Party or the Democratic Party in the way that legislators do. I do think that there are strong ideological and jurisprudential commitments among all 9 justices, and you see that those play out. And yeah, it's true that those judicial philosophies correlate to some degree, not perfectly though, with views and outcomes that different parties seek. And the Constitution sort of envisions that the elected politician, the president, ultimately is going to have the ability to put someone on the court, maybe because he agrees with their political philosophy instead of someone else's. But from what I know from the justices, from having worked there and having argued cases there, I think it's a very I don't think it's true to reality to say that there's no law at the Supreme Court. It's all politics. And I would, for those of you who haven't had the chance to go visit the court, I would encourage you to do so. And if you can't make it to Washington, I would encourage you to tune in to some of the oral arguments. And the kind of debate and discussion that happens at oral argument when a case is being heard at the court is very, very different from what you would see on the floor of the House of Congress, which I think reflects the fact that these are 9 justices who are doing their best to put their partisan commitments to the side and to apply their judicial philosophies as they see them to the facts in each case. And are people going to disagree with different opinions? And are conservatives going to point fingers and call names when they don't like a decision from the other side, and vice versa? They are. But I don't think that's how the justices see their role, and I think that by and large they do a very good job of keeping the politics out of it.
And yet, Justice Kagan interestingly described her concern that when the most likely explanation as to why the court has reversed ground relatively soon after making a certain decision is the change in the composition of the court, that looks like politics. And I think what she was saying is partially what was actually going on, but also partially how it appears. And the appearance has a lot to do with what I think Hamilton was talking about in Federalist 78, that the court does not have the power of the purse or of the sword. It has the power of judgment, but it actually has the power of being perceived to be acting out of judgment. And when it begins to lose that, I think then its power begins to fracture. 2 interesting observations of the recent court. One is that we get fewer and fewer surprises. And it's not so very long ago when presidents of both parties got surprises. Most famously, I suppose, President Eisenhower with Earl Warren, although I've never been completely sure he was quite so surprised. He was appointing a popular governor, and he got him to endorse him in the '52 election, and he got what he wanted, and Warren played a transformative role on the court. William Brennan was appointed by President Eisenhower as well. But you have Byron White, appointed by President Kennedy, who by most measures becomes a fairly conservative judge. And we can go down the line of surprises. David Souter turns out not to be as conservative as some Republicans thought he was going to be. John Paul Stevens certainly not as conservative as some Republicans thought he might be. We don't get surprises now. And I think that is part of the sense that there's something going on besides just engaging in the cases and the life of the mind. It's a fascinating law review article written some years ago about the judge who decided the Charlotte, North Carolina desegregation case back in the 70s. He was a, if you will, country club Republican appointed during the Nixon administration. The last thing in the world he was doing when he went on the district court bench was to desegregate the Charlotte-Mecklenburg system. And it's a description of how he felt the law just carried him in a direction that he hadn't really thought about, but he found himself carried there by the law. I think there's less of a feel that that's happening now. The other thing I'll mention is just arithmetic. I'm going to make the big assertion, say it's never happened before. It's probably not true, but I can't remember a time when the left-right divide on the court precisely fell with the party of the president who appointed the justice. It has usually been the custom that if you refer to a judge by the party of the president who appointed him or her, you are persona non grata in that courtroom. If I may just share a story, Robert Carter, who came up through the NAACP Legal Defense Fund and became a district judge in New York, I was in the courtroom about to argue my motion when somebody was in front of us who was arguing a civil rights case that had very little merit, and Judge Carter was having none of it. And finally, this advocate with nothing left to say said, but Judge, you're a civil rights judge. We all hid under our bench at that point because we knew it was coming. And Robert Carter stiffens. I can picture him right now. And he says, I am not a civil rights judge. I am a United States District Court judge for the Southern District of New York. Of course, we all said, Judge, if we take him outside and beat him up, will you be nice again and stop being so mad because we have to argue before you? Seriously, knowing the party of the president always told you a little something for obvious reasons. Let's not be naive. But it didn't tell you everything. The fact that it tells you everything now, I think, is very destructive.
Let me just jump in on that. I don't think it tells you everything at all. I think there are a lot of surprises. Maybe not in terms of individual justices sort of evolving in the way that some of the justices did in the past. But I think that the folks out there who talk about the conservative court and the 6-3 court, and it's just down the line, I think if you look at the record of the decisions over the last few years, that's not the story you see. Of course, we see big decisions, Dobbs, affirmative action, other cases that sort of went along those lines. But over and over again, we've seen coalitions of justices make common cause across this divide in major cases. Just to take a handful, when Justice Kavanaugh and Justice Barrett were up for confirmation, one of the big things that they were getting hit on was, Donald Trump is trying to appoint these justices so that they can overturn Obamacare. The Obamacare case came to the court, 7-2, upheld. I don't know if you were surprised, but that would seem to confound the thesis that this is a down-the-line conservative court. When both of those justices were up there, they said Donald Trump is appointing these justices because he needs them to vote for him in the case about subpoenas, or he needs them to look out for his interest in this upcoming election. The Supreme Court rejects the subpoenas claim, doesn't intervene in the elections. When Title VII came up, and the question was whether LGBT rights should be protected under Title VII, you had two of the conservative-appointed justices, two Republican-appointed justices, go to the other side and agree that to embrace a more expansive version of that statute. You had the Chief Justice repeatedly siding against Donald Trump in case after case involving administrative law, adding a census question to a citizenship question to the census, repealing DACA. So over and over again, we see these alignments, and they don't get as much attention because they don't fit the narrative. But I think the reality is that in these cases, if it were true that there was no law here, it was just politics. If it were true that there are no surprises, they were appointed by a Republican president, they're there to do Republican things, and vice versa, Democrat things, I don't think you would see these kind of surprising outcomes. Last term at the Supreme Court, Justices Sotomayor, Kagan, and Jackson were in the majority more than Justice Thomas was in the majority. I think that would come as a surprise to a lot of people, especially a lot of people who are hearing this narrative about the super politicized court, which I don't think is a fair narrative.
Great. All right, so I want to go back to, this is the kind of discussion we want, right? I want to go back, Ramon, to something you said. We're talking about the influence of politics on the Supreme Court, and you mentioned that we have two things, right? We have the influence of partisan politics, and then we have the influence of the political views of the justices. I think those are two separate things. And you noted that it's not always the case that the justices' political views line up with their interpretive perspectives, but often that's true. So I want to talk a little bit about the different interpretive perspectives the justices have. And one of those that we hear about all the time is originalism or original intent. Can you explain what originalism is, and can you also describe some of the other approaches that Supreme Court justices use to interpret the Constitution?
I think you get first shot on originalism.
I feel like I was on the soapbox for a second there, but I'm happy to take a first cut on the originalism. I think the originalism, it's sort of a fancy legal word, and maybe a word that sounds a little strange and a little scary, but I think it's basically the idea that laws, whether we're talking about the Constitution or whether we're talking about legislation that's passed, that laws should be interpreted to mean what they would have been understood to mean by ordinary people at the time that those laws were passed. And the idea is that we have a democracy by and large, subject to certain constraints imposed by a constitution adopted by we the people. And when we're interpreting enactments, either by we the people in the Constitution or by the elected representatives of the people, we need to honor democracy by essentially allowing the democratic will to speak through those laws as they were understood at the time. And then any other approach that allows a judge to take language and interpret it not according to how it was understood when it was passed by the democratically elected folks who passed it, but rather to take into account the preferences of the judge himself or herself or of a later time, would be anti-democratic and would also change the role of the judge. The judge would no longer be merely judging, but rather would be exercising will, to go back to the language of Federalist 78. So I think what originalism really is that common sense idea that if you have an elected group of legislators and they pass a law and they debate it and it has a meaning to them at that time and they try to enact their will into law, that later judges that come along should try to respect that and try to enforce that as the law.
So originalism itself is a political idea, right? So Ronald Reagan's Attorney General, Ed Meese, I think was the first person to say, you know what, we should start saying that the Constitution means only what the founders thought and nothing else. And then it kind of caught on and people thought, oh, that's going to sound a lot better than we want to interpret the Constitution in a way that prefers white men with property over everyone else. So it's a real, I mean, I'm sort of saying.
So originalism's racist, is that the idea?
No, but it's a real issue, right? So just think about originalism, this idea as applied to a constitution, not a statute that says, you know, how many years, X, Y, or Z, but to the Constitution. So what does equality mean in the 14th Amendment? What does free expression mean in the First Amendment? These are not narrow statutory terms that we say, well, how were they using that word? I mean, the idea of equality can't possibly mean the same thing in 2023 that it meant in 1789. It doesn't even make any sense to think about equality that way. When the Constitution was passed, people were enslaved. Women were legally subjugated to their husbands. They could not vote. They could not serve on juries. They could not participate in political life in any way. So for us to say, well, no, it's a neutral theory, it's just whatever they meant, that's what it means, is ignoring the fact that huge sectors of the population were by design excluded from all of those things. And so is that what we want, is for people in 1789 to tell us now, right, what equality means? Equality is a term that itself, of course, changes as society changes and as people change and as norms change. And I'm just going to give my one concrete example that I think illustrates this in a way you won't agree with. But so the Dobbs decision, which reversed Roe v. Wade and said, in fact, there is no constitutional right to abortion, even though there was one for 49 years. And part of Alito's majority opinion said, it can't be protected as a fundamental right unless it was well established in 1868 when the 14th Amendment was ratified, right? And he says, I'm just calling balls and strikes. I'm just saying, look at that, and if it was protected in 1868, then fine, and if not, not. So there are two things. Well, there are 18 things, but I'm going to limit to two. One is Supreme Court justices are not historians. They're not trained historians. Most judges are not. They don't have PhDs in history. So the idea that they're going to be able to construct a history from 200 years ago or 100 years ago and give us some definitive understanding of meaning at a time they don't understand and didn't live in is a very problematic idea. But in this specific context, he says, look, all I'm saying is it had to have been established in 1868. Okay, well, what was 1868? Women did not vote. In fact, they wouldn't vote for another 52 years in federal elections. Women were under the laws of coverture, so they had no legal identity if they were married. They could not sue or be sued, enter into contracts, own property, serve on juries, all kinds of other things, right? The other thing is, in 1868, scientists did not know how babies were made. They knew that they somehow related to sex, men and women, and a birth. And they did not understand what happened in between. No idea how pregnancy happened, no idea what would cause it to end or not end. And they figured that out in 1875, this real aha moment, like, oh my God, there's a sperm and there's an egg and they meet and there's a baby, right? But we're going to fix the time when we determine whether abortion is a protected constitutional right 7 years before they knew how babies were made, right? Makes no sense. Like, doesn't make any sense as a theory. So I think a lot of what we do in constitutional law and in constitutional ideas is we like to have neutral principles that sort of hide what we're really doing, and that's both sides. This is not not purely criticism of Republican or conservative ideologies, right? So we talk about federalism. Who's for or against federalism? The truth is, federalism, people like things controlled by the states if they like what the states are doing, and they like things controlled by the federal government if they like what the federal government is doing. And judicial activism, it's judicial activism if you don't like what the court did and you think they've stepped out of bounds, and it's not if you like what the court did. And originalism is a theory like that, which is, it's a way of sort of hiding what they're really talking about. And what they're really saying is that if you're an originalist, is that you believe that life in 1789 was about what it should be, and we should be bound by that 250 years later.
Well, I guess we know where they stand. Another Justice Kagan observation. She famously, in her confirmation hearing, said, "We are all originalists now." And some people thought that that meant that she was pandering to try to pick up votes from Republican senators that would not think that she was going to be a judicial activist as they would understand or be concerned about judicial activism. But I think Justice Kagan had something much more subtle and significant in mind. I think what she was saying is that the notion of originalism as practiced is actually bad originalism. It is not the way in which the founders expected the system to work if the system could possibly last for 200, almost 50 years. I mean, my sense, if we were to ask the founders what their view of how the Constitution be interpreted 200, almost 50 years later, their first response would be, "You're telling me this Constitution will still be in effect in that length of time? That is our highest aspiration. It's extraordinary to us that this will happen, and we will assume that things will change over time because things have changed in their lifetime, and it's only accelerated since then." It's what our math colleagues would tell us is a second derivative issue, not a first derivative. It's not just changing, it's changing faster. And so we assume that as things continue to change, you will change with it, and you will evolve with it, and that's what originalism would actually call for. So originalism, if you will, as an ultimate way of thinking about the Constitution, doesn't call for fixing things in 1787 for the Articles and for 1868 with the 14th Amendment. Justice Breyer, in his book on active liberty, describes this as a process in which courts play a role of interpreting the Constitution in light of its original sense, but as that applies as we move through time. So, for example, in a firearms case and the right to bear arms, as arms have changed over time, that certainly might be a factor. In the question of whether search and seizure under the Fourth Amendment should apply only to searches of a home, which is what was thought right up until the 1960s, when the court changes and begins to look at things in terms of an expectation of privacy, which you might have someplace other than your home. The original case where that was decided was a wiretap case, where the court said, Fourth Amendment is about trespass. No trespass with a wiretap put in a phone booth. Justice Brandeis, dissenting in that case and presaging what the court will pick up in the 1960s, says, but people have an expectation of privacy. We should be paying attention to that. Where did Brandeis get that from? He didn't just look at what was written in 1787. He viewed that as something happening more over time. Let me use one last proof text for this. The very odd, puzzling language that we know so well that we don't pay attention to what it means. In order to form a more perfect union, what does that possibly mean? If something's perfect, it's perfect. How can it be more perfect? To me, the only intelligible way to understand a more perfect union is that it's a continuing process and that judges have a role to play in that. And to be perfectly fair, sometimes they're going to do things that are going to make me crazy. And when they do, I will accept their methodology if they explain how they're getting there, but that they have the right to do that and that that's their role as judges.
So I guess there's a lot to respond to, which I don't think we have time to respond to everything. I guess what I would just say is a couple things. First of all, everyone agrees that the law and the Constitution have to work in today's world. I don't think there's any disagreement with that. I think the question is how are we going to update it and who's going to do the updating? And I think the idea behind a kind of originalist sort of philosophy, and I think it's a philosophy that's really encapsulated in Federalist 78 itself, is that the judges are not the people who should be there figuring out what the rules of society should be. That's really a job for a legislative body or for we the people when we're amending the Constitution. And so I think the Constitution does envision that it has to change, but it envisions that it has to change through an amendment process, which I think, frankly, is too hard. You know, I think that it would be better if we had an amendment process that would allow popular majorities and you know, people throughout the country to be able to amend the Constitution a little bit more easily than they can do, because I think that would alleviate some of the pressure of having to go to courts all the times. But I don't think it should be judges. And frankly, if I were a liberal, I would be very worried about giving judges expressly and telling them, yeah, we think you guys should have the power to make up the rules, because I think they would be unconstrained in ways that a lot of liberals out there would not like. Cass Sunstein, who's a very, very smart, very accomplished professor of law, has a book coming out on constitutional interpretation. And I have not yet read it. I don't know if it's out yet. But I read the blurb, and here's his theory. I do think it's fair to ask, you know, if you're not going to be originalist, what are you going to be? And so Sunstein says, or at least his publisher says, when describing the book, that the only way to choose what the right method to interpretation is to ask whether it would change American life for the better or worse. So it's basically this kind of free-flowing utilitarian. I mean, do you really want to give my friends, my former boss, Justice Kavanaugh and Chief Justice Roberts and Justice Thomas and Justice Alito a blank check and tell them, just figure out what you think is best for America, and you should just do constitutional law that way? I mean, I think that's almost a lawless way of doing adjudication.
I would argue that is what they're doing, though.
Oh,
I think there's already a blank check, right?
But let's test it, though. Let's take Dobbs, which is a hard case for the conservative side because it's one of the most constitutionally contentious issues. I don't think the court said, let's assume that the Republican position on abortion is pro-life and the other position
We don't
is
have to
pro-choice.
assume that. That's true.
I don't know what the justices' positions are on pro-life or pro-choice myself.
I mean, you know what Justice Kavanaugh's position is.
absolutely don't.
He wrote opinions in prior cases on the D.C. Circuit in which he very much said.
No, but I don't know whether he's pro-life or pro-choice. I know what his views are on the Constitution. And I think what Justice Kavanaugh said in his opinion in Dobbs is that this is an issue that the Constitution doesn't cover, and it's an issue that the people should get to decide. And so, if you thought that all they're doing is politics, then wouldn't the answer be to say, oh no, the Constitution requires the pro-life side to win? And that's not what the court said, and I don't think that's what the court is going to say. So
well, but the Constitution already, at the time he said that, protected abortion, right? So he says the Constitution doesn't cover this, except for there is a binding Supreme Court decision saying this is a constitutional right, and they got rid of it. So he likes very much in these opinions, and not just in Dobbs, to play the sort of, I'm just the neutral guy. I just want to sort of make everybody happy. I'm just being neutral. The reality is he removed a constitutional right that existed.
that the court had created in the
Just
70s.
like it created every other individual right under substantive due process. The right to the care and control of your children, the right to not be sterilized against your will, the right to use contraceptives as a married person, the right to use contraceptives as an individual person, the right to marry a person who is of a different race, the right to marry a person of the same sex. There's no difference in any of those rights as to who created it, where it came from. It's not in the text. None of those things are in the text. There's not a mention of parents, children, women, sex, marriage, households. None of it's in the Constitution. So all of those things came from the same place. So
Right.
for him to sort of say, oh, well, this isn't in the Constitution, so all I'm doing is giving it back to the people, he's removing a constitutional right because he doesn't like it, right?
Right, but I think if I'd understood your position earlier, if the idea is that there's no law, there's just politics.
I never said there was no law. I
Okay.
said that fundamentally the Supreme Court is a political institution.
Right.
That doesn't mean that there's no law. Of course, they're interpreting statutes. They're looking at law. There's briefing. There are lawyers, lots of lawyers. It's not that there's no law.
Okay, so there is law. I think that if you just take the Dobbs example, I think that the originalist position would say the Constitution's neutral on this. We'll let the people decide. The two extreme positions on either side of that would say the Constitution decides this, and it decides it in a way that I want. And I just think it's very hard to take that decision away from the people in the absence of constitutional language or history that sort of puts it.
But when a
in people's
fundamental
hands.
right is involved, and query whether there's a fundamental right, that's the issue in Dobbs. But if there's a fundamental right, of course it doesn't get left to the
I agree.
to the people, and that
Right.
so that begs the question of who makes that decision. And so the list that you presented was a list of fundamental rights that the court has created, if you will. And so do I, with some trepidation, say that I believe in judges playing this role? I remember one of my very liberal professors in law school saying, since we were all good judicial activists in the 1970s in law school, he said, why don't you take a list of all the then 100 justices of the court, write them down on pieces of paper, put them in a hat, and pick out 9. Take a look at those 9 names. How do you feel about those people exercising judicial activism? So I get that piece, but my judicial philosophy would largely follow something of a judicial pacifist, Louis Brandeis, who did believe in the role of the people, did believe in the legislature, but also believed in fundamental rights that should be insulated from that political process.
Right, but how do we decide which fundamental rights should be there when we're
that-
looking at things that
Well,
don't appear in the text
the-
or in the history?
We could do one of two things. We could say if they're not in the text, then they don't exist. I guess that's the originalist position. Or we could say that a document that's going to exist for a quarter of a millennium is going to have some give in the joints, and we will have justices who will play that role. That's why I said I'm sure I'm going to be unhappy.
And you would give that power to our your 6 friends on the court right now who were appointed by the Republican presidents. That seems like
I would give that power to a Supreme Court confident in the notion that in the past that has served it well, and in the fullness of time it will serve it well.
I think you're going to get a lot worse results if you tell the justices just go at it. I think that they are bound by law. They operate as under these constraints, and I think that these are very real constraints. And I mean,
Like, what are the constraints?
They don't.
Like, give me an example of a
talk
constraint.
like they're under constraints. And
I think there's a debate on the right where there's some folks out there who have a view that there's a personhood sort of theory of abortion, that the Constitution affirmatively protects the right to life, essentially, such that states could not, in fact, make abortion illegal. That is a view that is out there. I think that is a view that is inconsistent with what Justice Kavanaugh said is the right way to think about this issue. And so I think that's if we were to assume that he's pro-life, which I don't know if he's pro-life, but if he were pro-life, he would be saying, look, even though I'm pro-life, this is not for me to decide. If California and New York and a whole bunch of other states want to protect abortion, they should be allowed to protect abortion. I would have to uphold that. And so I think that's a very real constraint. I think we see the constraints in the long list of cases that I mentioned earlier, where maybe those justices wouldn't agree policy-wise with those decisions, but they nonetheless made common cause with the left side of the court and reached outcomes that I think would surprise a lot of people. So I think we see the constraints and we see them cashing out in important decisions all the time.
I mean, first of all, the personhood question, while very much part of the anti-abortion platform, hasn't come to the court, so we don't know how they would rule. But I don't see that as a constraint. The fact that they haven't done that doesn't mean they can't, or that they feel like they can't. They might think it's too far, that there actually would be even more of a pariah in American society than they might already be, going as far as they did. There is nothing stopping them now from adopting constitutional personhood. There's nothing that's stopping them.
I think their own judicial philosophy would stop them from doing that. Whereas I think your judicial philosophy, at least as Fred articulated it, which is sort of basically giving the judges a blank check, actually would tell them, hey, if you think this is morally right, then go ahead and enact it into law.
I'm going to stop this so that we can talk about other things and not just... I will say, I do think... Okay, I'm being unfair, but I do think saying that these other judicial perspectives are untethered is not quite right? Because the right to privacy, the decisions regarding the right to privacy were tethered to things like the Fourth Amendment, the Ninth Amendment, and those kind of things. But so I'm going to ask one question, and then I'm going to go to audience questions. Are we having this very robust debate because part of the problem is that the Supreme Court feels out of step with the majority of the American public? I mean, we're talking about, are they politically accountable? Should they be politically accountable? Are they influenced by politics? Are we at this moment because there is maybe a sense that the court doesn't reflect the views of the people, and should they?
I think there's a lot of things going on. I mean, I think that's part of it. I think in part, the Supreme Court we've given them too much power and look to them to do too much. And that's, liberals have, by and large, right, looked to the court to recognize rights, to protect them. And have had a lot of successes, lots of losses, but some successes. So we imagine the court being the savior. And so now for it to not only be not the savior, but actually the aggressor is a very hard moment, for people who have my views. But I think in general, we have put too much on the Supreme Court, and now that it does not seem to be holding up to what we think, and I think it'd be very hard to argue that this current court has not delegitimized the court to some degree. Because people's perceptions, if you just look at opinion polls of favorability of the Supreme Court, right, the lowest they've ever been in all of history right now, like in the last year.
Almost as low as the president, right?
Yeah.
No, but if you want to say, like, why do people criticize the court? Why do I say, I'm a law professor. I have to talk about courts all the time. I talk about decisions. It has become very, very difficult to teach law because there's not any sense of predictability or reliability, and say, why did the court do this? Dobbs, there is no answer except for that there are more people on the court who are opposed to abortion than who favor it. That there isn't any other way to explain it. And I used to feel, I've been a law professor for 25 years, most of that time, I was a big go courts, go law, I love the law, it's fascinating, it's interesting, let's do this. I'd explain, and we have precedent, and we're doing this and all that and the other thing. I was in the game, right? And now I think I'm at a moment where I think I've been duped, and law is fundamentally just political. And I think that's a very hard moment. I don't know what's gonna happen, I don't know where we're going from there, but I think we have to accept that there's something going on here that is not what we are used to.
So to follow up, I'm going to actually go back to, so this I think is related to this, what we're talking about now, but I want to go back to something that Roman said. I mean, is part of the problem, Roman encouraged all of you to go to the Supreme Court and listen to argument. And I have a question here. The court has, for the most part, operated behind closed doors. This is different from congressional hearings and meetings, which are televised and shared online. Now, the court now, I guess you can listen to argument, but and obviously their deliberations are never going to be made public, but should the Supreme Court hearings be televised? What are some benefits and downsides to keeping them offline?
So
I'm gonna bet that we're gonna agree on this one. Let's see if I'm right.
So I have a nuanced position, which is I guess I was wrong. I think transparency is very good for the court, because I think that what the court does is special and unique, and I think people will have more confidence in the court if they actually sort of are able to engage. I think that television cameras probably go too far. I think there's a danger, having argued cases there, and sometimes, especially in the higher profile cases, started to see a little bit of it. But I think there's a danger of sort of playing to the crowd instead of trying to argue the legal points. I think television probably encourages that too much. But I'm very, very happy that the court changed its policy during COVID to air the oral arguments live. I think that kind of transparency is really positive. I'll just tell one little story, which is it got a little too transparent for me. I was arguing a case during COVID, in the very early days of COVID, and it was one of the first ones that was not like a super, Bush versus Gore level case that they were airing live streaming, and we were doing the argument by phone. And I was arguing from my office, and it turned out the justices didn't really know how to use the mute buttons. And so I was arguing this very tricky case, and I got to the key part of the argument where Justice Kagan was basically cross-examining me. And in the middle of one of her questions, there's this loud noise that turns out to be a toilet flush. Oh, no. So sometimes too much transparency can be a problem. But in general, I think the court has made an effort to be more transparent, and I think that's positive.
All right, so I think we are close on this. I said we're all going to be on the same side. I think I'm going to lose that one, but I think we are close. I think televising would not bother me. There's some playing to the crowd. Did you mean advocates or the judges, the justices? Yeah, I think there's some playing to the crowd that goes on with justices anyway. Would this exacerbate it? Maybe, but maybe not, and maybe that's not the risk. I think many of us who've had the experience in the COVID and now post-COVID world, I know when I teach, every one of my classes is recorded now in case a student wants to watch it. Most of them are live streamed if students are out of for illness or some reason. I won't deny the first couple of times that's a little weird. You really do forget about it. I teach my classes now, and I really don't pay attention, so I think to a certain extent that part washes out. And I think the countervailing benefit to the public of actually watching the court, and maybe the benefit to the justices of knowing they're being watched. But after all of this sort of hot button issue about polarization on the court, I'll share one little story where if you weren't in the courtroom, you never would have known this moment happened. It's a case called Wisconsin against Mitchell that I was closely involved in, involving the first time the court upheld a hate crime statute, which is what most of my early scholarly work was about. There was a moment when Justice O'Connor asked a question of Jim Doyle, the then Attorney General of Wisconsin, who was arguing, and it's just fair to say that Doyle swung and missed. He just didn't give a good answer to it. Justice Souter does a follow-up question, and it's clear to everybody in the room what's going on, which is that Souter wants O'Connor to get a better answer to that question. So he asks a follow-up question. You watch the light bulb go off over Jim's head, and staring directly at Justice O'Connor, he answers Justice Souter's question. That's real advocacy. And I think that would be the kind of thing that would be very valuable for the public to know. And you never see that if you didn't happen to be in the room. Why should that have to just be in the room?
Yeah, I mean, basically, I'm in favor of more transparency. I understand some of the reasons why the Supreme Court has been slow to it, but I think generally more information is better. I go to Supreme Court arguments a lot. I enjoy doing that. I think you learn a lot from being there in person, and you also learn a lot about what the opinion's going to say 9 months later because you watch the way they ask questions, you listen to the questions. There's a lot of information there. So I don't see a particular reason to cloister the Supreme Court in ways that other courts are not.
All right, so going also to the question of, I think really what we've been circling around all evening is legitimacy, right? And you know, people's perception of the court. So we've had a lot in the news recently about particularly Justice Thomas receiving money, perks, all kinds of things. Can you, and so, you know, in the ether right now is discussions about should the Supreme Court have a tighter code of ethics? And so that's my question. Should there be a code of ethics imposed on the Supreme Court? Should it be imposed by the justices themselves? Should Congress do it? And would it be enforceable if there were one?
So I'll just start us off on a kind of softball note, which is one of the things that contributes, I think, to the idea that the Supreme Court actually has no constraints and can do whatever it wants is the fact that it doesn't have an ethics code, right? It also is not bound by federal anti-discrimination laws. So they can discriminate against their clerks, they can do all kinds of things, and the normal workplace protections that congressional employees have and executive branch employees and everybody else who's covered by those statutes, the judiciary is exempt from most of those laws. So that doesn't, you know, I think this idea that the court is something special and they can't have any constraints imposed on them is not helping any of this situation or these perceptions. It seems to me completely reasonable that the judges would be covered by an ethics code and that they would be covered by anti-discrimination laws. Now, what that should look like, the anti-discrimination law is easy. You just change the one word and say judiciary not exempt, done. One lawyer, 1 hour, you're done. The ethics code, I think, is more complicated to think about what, you know, how do you want that to work? Who do you want to enforce it, et cetera. But I think what we've seen in the last, you know, certainly in these recent stories is there has to be something. There got to be some rules.
I don't know why the justices wouldn't want the same ability to say we're bound the way any federal judge is on basic rules of reporting and basic rules of conflicts. I spent 5 years as an assistant U.S. attorney. We knew that you never took anything from anybody. That's an easy one to remember. I mean, I remember being with a lawyer at lunch, and actually, it wasn't lunch, it was a cup of coffee. He reached for the check for a cup of coffee, and I said, I assume you're kidding. I said, the answer to the question, did anybody buy you anything, is no. Not yes, but it wasn't really very much. And I didn't think I got a gold star for that. That's what we all did. Those were the rules. Most federal judges have no problem with these rules, and I have a hard time understanding why the Supreme Court doesn't take it upon itself, and if it doesn't, then I start coming up with bad explanations because I'm having a very hard time coming up with a good explanation.
I think the ethics is very important. I think that the court has said that, you know, the Chief Justice put out a statement about a year ago or 9 months ago that was on behalf of all 9 justices saying that they do follow the ethics rules that formally apply to the other tiers of the judiciary. I think it would be good if the court were to formalize that on their own. I think the hard problem, and I think it is a very hard problem, is the question of enforceability and the question of recusal. Because in the lower courts, if a judge is recused from a case, it's very easy to replace that judge on the particular case. At the Supreme Court, you can't replace a judge who is recused. And so there would be a huge incentive for litigants on all sides of every issue to try to find ways and sort of come up with conflicts, in some cases to create conflicts that would require recusal, I think that poses a particularly challenging question for the court, and I think that's one of the reasons why they haven't been more formally bound. My impression from the public comments coming out from a wide variety of justices, all ideological stripes, is that they're working on something, and my hope is that they will put something together.
And of course, with the Supreme Court, if you have a recusal and you have 8 justices, you can't have a majority, right? And so that's kind of part of it.
And it can shape exactly how cases are decided.
All right, I have one more question for each of you. The new Supreme Court starts, the new term starts next month. Any predictions you could make about upcoming trends or rulings?
And we have how long to do this?
You have 9 minutes.
So I'll make two general predictions. I'm not going to predict particular cases, but I do think the vitality of the administrative state will be very much at issue and will take a hit this term, or this term probably, and the 10 terms to come. And we've seen some of this along the way in the ability of the administrative state to play the core regulatory role it's played in the life of a complex society, complex modern society since the 1930s, is, I think, in peril. So that's one issue. And the other is, I think, that continuing the direction of using religious arguments as exemptions to otherwise generally applicable laws, a doctrine articulated by that famous left-wing liberal, Antonin Scalia, will continue, and I think again to the detriment of the republic.
So I think 2 things. First, I think the court will continue to have some surprises that where the ideological lines will be jumbled. I think, yesterday we saw one piece of this, sort of a carryover case from last term, an important voting rights case, where the Chief Justice and Justice Kavanaugh joined with the more liberal justices to strike down a district in Alabama as a violation of the Voting Rights Act. They made that decision last term. Alabama refused to essentially follow the mandate of the court and tried to write another plan that didn't really comply with what the court had said. A lot of people thought that this was going to be an opportunity now for the court to come in and somehow side with Alabama, even though they had just ruled against them. The court just ruled against Alabama yesterday without any noted dissent. So I think we'll see some other kind of somewhat unexpected alignments this term. I actually think the other issue that's super important that isn't, or probably shouldn't be super ideological, but is extremely important, is the question of how the First Amendment applies to social media and the internet. There are a series of cases heading to the court right now in which Florida and Texas have tried to pass laws that essentially are geared to prevent social media companies from censoring or blocking sort of conservative viewpoints. And I think you can imagine similar laws that sort of raise similar questions coming at it from the left of center, the left side of the spectrum as well. The court hasn't really figured out how the First Amendment operates in this public sphere very clearly yet. And so I think this term we might get some clarity on that, and I think it'll be a hard set of cases for all 9 justices.
I would just add one other case I'm keeping my eye on, which is a
Mike.
case about the constitutionality of a law that prevents convicted domestic abusers from having firearms, and whether that is consistent with the Supreme Court's new take on the Second Amendment. And I think that's, first of all, going to be important just on the general, how far are we going to take our suicide pact on guns? And second of all, it's going to be an interesting test for originalism, since men at the time of the Second Amendment had the right to beat their own wives as part of coverture and the right of chastisement. So it's going to be hard to have an originalist take on taking firearms away from abusers. They didn't have handguns and they could beat their wives. So I will be interested to see what this court comes up with. I fear that they are going to strike down this law, which is going to drastically restrict the ability of governments to protect people from firearm homicides in cases of domestic abuse, and that will affect Texas specifically. Dallas has been doing a lot of work, thanks to, in part, our clinic at SMU, not my clinic, but my colleagues, working on gun surrender laws and dealing with the problem of firearms in the hands of domestic abusers, which increases the chance of a homicide by about 500%. So I think that's going to be an important case that I personally am watching.
And can I just end on a point of agreement? I think you're right that this is going to be a hard case for an important case for originalism, and to see whether originalism can be made practical. I think one of the challenges to originalism is the fact that history can be hard to do, and I think originalists recognize that you have to update. You have to take the principle at a level of generality where it can apply to new facts and new developments. I don't think that's inconsistent with originalism. I think it's part of originalism, but it's still hard to do, and I think the court is going to wrestle with that very strongly in the case that you mentioned, and I think I'm not so sure how they're going to come out on that one.
I'm not either, but
You heard it here first, folks. Well, thank you so much to this amazing panel. Thank you for the robust discussion. I had about another hour of questions, but our time is up. So thank you also to the audience and to the Dallas Holocaust Museum for hosting us and encouraging us to engage in civil discourse. Thank you.
Thank you all so much for spending your evening with us. Thank you all for being here. We look forward to continuing these conversations, so please come back for the next Civil Discourse Series discussion. Good night.